Bar 2025. Criminal Law. Question number 19 by Amicus Curious. A and B got married during the pandemic. They had a daughter named C. They rented a house and lived together until 2024, when they parted ways. A then moved to her parents' house. Initially, B sent part of his monthly salary to A, but he stopped after a few months. For the next 3 years, B failed to communicate with or provide any support to their child. As a result, B was indicted for economic abuse or violation of Section 5(I) of Republic Act No. 9262 or the Anti-Violence Against Women and Children Act. In his defense, B claimed that he did not intend to withhold support from A and C, but since his parents got seriously ill, he had to support them instead. Is B guilty as charged? Reasons. No, B is not guilty of economic abuse under Section 5(I) of RA No. 9262. While the law penalizes acts that cause economic harm to a woman or her child, such as the willful denial of financial support, the Supreme Court in Acharon v. People clarified that this offense is malum in se. As such, it requires proof of both the act itself, actus reus, and a guilty mind, mens rea. To be criminally liable, it must be shown that B intentionally withheld support with the purpose of causing mental or emotional anguish to A and their child. Mere failure or inability to provide financial support, especially if due to competing obligations like caring for seriously ill parents, does not automatically amount to economic abuse. In this case, B's explanation that he redirected his financial resources to support his ailing parents may negate the presence of criminal intent. Without clear evidence that B deliberately sought to inflict psychological harm through the denial of support, the prosecution cannot establish the required mens rea. Therefore, B cannot be held criminally liable under Section 5(I) of RA No. 9262. This is just a suggested answer. Use at your own risk.